Cindy indicated, I hope that you've downloaded the materials, particularly the forms that were listed there, the bankruptcy forms, as I'm going to in-depth review a number of those items, which I think would be of interest to you. Possibly some of you participated in a webinar a couple months ago that I presented on, which I called Bankruptcy 101, which was a very basic course. The intention of this presentation is to go a little more in detail and give you some examples of some things that you definitely will want to take a look at. And so from time to time, I'm going to be going back and forth. The materials I've provided, I'm not going to follow the materials. So if you're accustomed to having them in front of you and then going page by page or paragraph per paragraph, that's not the style I'm going to use today. I apologize for it. Hope that doesn't upset anyone. But basically, we're going to go through the various things of what I think are items that you definitely want to be aware of. I realize that some of you may be responsible for handling all bankruptcy activities at your particular institutions. Others may just get the information, compile it, and possibly turn it over to an in-house counsel or an outside attorney that has expertise in the bankruptcy area. Either way will work extremely well. I will attempt to caution you on some of the points that if you are handling or trying to handle things in-house, that most likely at some point in time as you do get a bankruptcy that gets very involved, particularly if it deals, unfortunately, with a large customer or a large credit that your institution has, that you may want to bring in a specialist, an attorney that specializes in bankruptcy. We'll also discover some of the court decisions that impact creditors such as yourself. Intentionally, I've not given you a lot of citations. Some of you may be counsel for your banks, and I apologize for not giving you direct links to those pages and references in the legal materials, but I think you'll be able to find them from the description of the cases we'll be talking about. We're going to cover, I'll go through some of the items here, the topics. Let me get back to topic coverage. I think I've skipped one particular slide here, just a second. Okay, here we go. We're going to discuss the automatic stay. We're also going to talk about cram downs as they deal with both the Chapter 11s and Chapter 13s. We're going to talk about the hanging paragraph, which some of you might have heard. This is kind of an anomaly that was discovered in the Bankruptcy Code when it was enacted. Ironically, at the time the Bankruptcy Code was passed back in 2005, that everybody thought that was a massive piece of legislation. Well, compared to everything that's coming out in the last year or two out of Washington in congressional activity, it's really a smaller piece of legislation, but it still contains a lot of material that the regulations, believe it or not, are still being written to final rules. In fact, I'll mention a couple that just were only actually finalized in May, some period of time, obviously, after the legislation was enacted. We're going to go through the bankruptcy forms in detail, bankruptcy petition and schedules, and point out some of the areas that you'll definitely want to take a look at if you receive notice of bankruptcy being filed by a customer, to determine exactly how much time and effort you're going to need to spend on the particular case. We're going to talk about the requirement of mandatory credit counseling for the debtor, and also how that may impact you, and how some of those actions you may be requested to take a look at some recommendations from a credit counselor as to how your credit may be paid off, the obligation owing to your institution, which can impact you. We're going to talk about the certification required by debtor's counsel, which is a very important point to acknowledge that there is attorney involved. If there is, if not, one of the consequences is that most likely the debtor will have to appear before a bankruptcy judge before any definitive action is taken in the bankruptcy case. We're going to talk about what we call a 341 hearing that comes from the section of the code. This is basically an outstanding opportunity for you to find exactly what's going on with your collateral. Hopefully you've got a perfected security interest, and it gives you an opportunity to speak and under oath make inquiries to the customer to find out what the relationship is that they may have with other people involved with the credit. You can find out where the property is located and some other things we'll talk about. Another thing that comes up from time to time is, can you post the checks that have been presented to your institution by drawn on an account of a debtor, whether it be an individual or a corporate entity or some sort of business entity, those checks that are post-petition to the bankruptcy being filed. We'll also, let me get these slides in order here. We'll also talk about, okay, here we go. Reaffirmation agreements, a very important document. In many instances, you're going to have to, or someone from your bank is going to have to provide information for that agreement to be correct, because it's going to have to contain accurate information from your loan documents. We'll talk about whether you need to file a claim, and if you do, whether what information is required. Automatic debits and automatic renewals, the importance of once you've received notice of a bankruptcy being filed, to make sure that there's any type of automatic notices that may be going out to the customer that may be considered an effort to collect a debt, that those need to be terminated. I'm going to talk about any disposal you maybe have of repossessed collateral, and what I'm talking about is if you still have control of that collateral after you've repossessed it, but prior to that being sold or liquidated, that you receive notice of bankruptcy. In most instances, you're going to have to immediately terminate those disposal efforts, or possibly invoke the wrath of the bankruptcy court. Collection efforts, can you have any contact at all with the customer? Yes, you can, but under only specific situations. And then we're going to talk about what type of notices you may receive from the bankruptcy court, and the importance of those, of completely understanding what those notices tell you, and make sure you don't miss any deadlines. So let's go on to what's probably everyone's heard about, even if they don't deal in the bankruptcy, but the automatic stay. The automatic stay in bankruptcy is a procedure that protects a debtor from its creditors. That's what it's designed to do. It basically prevents a creditor, such as yourself, from collecting on a debt that has been incurred by the debtor. The stay is effective immediately upon the filing of the bankruptcy. And by filing, I mean the case is presented to the bankruptcy court, either electronically or in person. A case number will be immediately assigned, and once those two things happen, that bankruptcy is effective, and any action that you take afterwards, in some instances, can be recalled by a bankruptcy trustee or a bankruptcy court, even if you have not been made aware of the filing at the time you take the action. So it's a very definite point in time. And one of the saving graces is, as we'll go through the materials and the forms, is that the party that's filing the bankruptcy, whether it's an individual or whether it's a representative of a business entity, is required to provide information regarding all of their creditors. And so your name should be listed. There should be information provided so that you can be timely contacted by the court, providing you notice that bankruptcy being filed. But even in the meantime, if that information is not correct, if it turns out that you knew of or should have known of the filing of the bankruptcy, you still may have to follow the instructions of the court. I apologize on this particular slide and a couple others you're going to see in the slide deck. I don't know what those, I'll call them, we talk about the hanging paragraph in a little bit, but I've got kind of some words that are kind of out there in the woods, so I'm not sure why they're there, but I think you can figure out what I'm trying to say. Basically, you can request relief from the stay which would prohibit you from taking certain actions by making an application to the court. A motion is made. A hearing may be required, but there is an opportunity to get that stay lifted. But basically the situation is that you cannot in any way continue any of your collection efforts. By collection efforts, I mean you cannot continue, when I say you,